Good morning, everyone. I'm Kimberly Chalia with PHCA. Thanks so much for joining us for today's webinar. A few quick updates to share before we get started. This webinar is being recorded and will be made available on the PHCA website. The webinar has been approved for one continuing education credit for all PHCA members in attendance. For those who provided a NAB number at registration, credits will be uploaded to NAB shortly. As we begin today, all attendees should be in listen-only mode. Please feel free to submit your questions utilizing the chat icon at the bottom of your screen, and we'll make sure to answer as many of those questions as possible at the end of today's presentation. And now I'll turn it over to today's presenters.
Well, good morning, everyone. Thanks so much for joining us today to talk about one of my favorite topics, employment law developments impacting our long-term assisted living and home health care providers. My name is Josh Vaughn. I am a shareholder at the law firm of Littler Mendelsohn. For those of you who may not be as familiar with myself or my firm, I am a wage and hour defense attorney. And my firm is full of attorneys like myself. We have more than 1,200 of us here domestically in the US and another 500 employment law defense attorneys around the world. What this means is we typically just represent companies with any related employment issues, from pre-employment to current employment to termination of employment, litigation, counseling, so on and so forth. I myself have a background in wage and hour law and specifically in assisting clients in the healthcare, home care, long-term care industries. Joining me today is my now good friend after a couple of years of doing these presentations together, Asher Brody. Asher, if you want to take a moment to introduce yourself, and then we'll jump into some of our agenda for this morning.
Thank you, Josh. Yes, good to see everybody. Good morning, everyone. This is Asher, and I am the co-founder and CEO of ESHYFT. So ESHYFT is a technology that connects nurses with nursing homes and long-term care facilities, kind of like an Uber for nurses. So we're a staffing agency, but we do it through technology. So we have nurses on one side of the platform and nursing homes and long-term care facilities on the other side of the platform, and we connect them through technology. So I hope some of you have heard of ESHYFT in the past. My background is in long-term care management. So I've been where many of you have been sitting for many years. For approximately 10 years, I was running assisted livings and nursing homes on the operational side. So I'm very familiar with how good agency is for a building and potentially how bad agency is for a building. I know what ticks the building to the positive or to the negative. So I'm familiar with where everyone here is sitting. And we're going to talk today about employment law and being compliant and how much responsibility we have as facility operators and owners and managers to, when we contract with an agency, how much responsibility is on us, how much responsibility is on the agency. Some agencies pay their employees as a 1099, some pay them as a W-2. Is that right? Is that wrong? We have a lot coming. Josh is full of knowledge and full of energy and full of humor, and I'm excited to kick this off to talk about some real-life scenarios. I hope Josh will be able to have time either during or if there's a way to submit questions. If there's something on your mind that you never wanted to pay a lawyer to ask, now's your time to ask, as long as it's within the wage and hour or employment law spectrum. But if there's something on your mind, how do breaks work? How does hiring work? Things like that. We're going to cover a lot in the presentation, but feel free to ask and we'll be happy to help. Nice to see everybody and looking forward to hearing what Josh has to say.
Thanks, Asher. And for those joining us this morning, you'll be very thankful that I've presented many times with Asher, because he typically brings me back down to earth. When I start talking the legal gobbledygook, he's got the practical experience of, wait a second, I've run one of these facilities. What does that actually mean? And so hopefully you'll be the beneficiary of his practical guidance to me in the past. You heard us briefly mention that Littler is 1,200 attorneys here domestically. I've got this fun little slide that talks about where we are. We talk about being local everywhere. These are just our physical office locations. 57 U.S. offices in 37 states, and for all I know, in the last 15 minutes, we might have opened a new office in another state. But what this doesn't show is that we do have attorneys barred in every U.S. jurisdiction. And of course, Pennsylvania, my home commonwealth, I'm based out of Pittsburgh myself. We have 2 offices in Pennsylvania with, I think at this point, 50 to 60 attorneys, one in Philadelphia, one in Pittsburgh. And so this is where we live. This is what we do. And we certainly keep Commonwealth employers close in mind. So what is our agenda for today? Well, it's pretty ambitious. In 2024 and projecting out into 2025, there are some, even just on the federal side of things, there are some changes, both changes that have occurred, changes that were proposed but got rejected. And so we're going to try and cover those. It's also important to me to try to leave you with takeaways. I don't want to just be Chicken Little, the sky is falling, talking about litigation and mistakes that get made and DOL audits. I'd also like to provide you some very concrete ways that you can help protect your building, your facility, or your employer when it comes to employment law issues. So here's our agenda: several DOL updates, Department of Labor updates. That's a federal agency that enforces the wage and hour laws. We've got an FTC non-compete ban update, and then we've got some NLRB updates. You see a lot of alphabet soup. In what I do in employment law, we're dealing with alphabet soup all the time. FTC, Federal Trade Commission, NLRB, National Labor Relations Board. These are all just federal agencies that can put out rules or enforce rules that apply to employers. Now, it wouldn't be a presentation with a lawyer without a little bit of legalese up front. I'm not going to read this. The general takeaway is this presentation is not an attorney-client privileged communication that's intended to give legal advice. This is for educational purposes only. If you would like to get legal advice, we simply encourage you to consult legal counsel of your choosing. If you happen to call me, I'd love that. But if not, at least call your counsel of choice to get specific legal advice regarding any specific matters you may be facing or questions you may have. Asher is right. Excuse me. Asher's right. You can absolutely submit questions in the chat today. If they're general education questions, I will do my best and Asher will do his best to answer them. If they need some sort of attorney-client privileged conversation, that'll be something we can address after the webinar. So, okay, jumping into it now with the U.S. Department of Labor white collar exemption rules. This is the most current update I will give you all day. This is something that literally just changed last Friday. So just baseline, what are we talking about? In order to classify a worker as exempt, so thinking of your DON or thinking of your chief operations officer, folks who are under the white collar exemptions, executive, administrative, or professional, there are 3 requirements, and you see them on the screen right now, and I think of them as a stool. If you lose any one of the legs of the stool, you lose the exemption. And what is an exemption from? It's the obligation to pay overtime. On one hand, we have non-exempt workers who you have to pay overtime to if they work over 40 hours in a week. On the other hand, you have exempt workers who you do not. The title or classification alone is insufficient. They have to meet these 3 tests. Now, the duties test is the most difficult test to figure out, but fortunately for our purposes today, we're not going to dig deep on that because the thing that has changed is the salary level requirement. So what has changed? And frankly, what has not changed? Spoiler alert. So prior to June 30th, 2024, so just a few months ago, the salary level in order to classify someone as exempt, in other words, what you had to pay them, was $684 a work week. Not every 2 weeks, not every year. It's a work week by work week test. Did you give them at least that amount? If not, you cannot classify them as an exempt worker under the executive, administrative, or professional exemptions, except for certain nursing positions. That's a separate conversation. Current salary level, and this says current because I simply haven't updated the slides since last Friday. We submitted these slides way before last Friday. It says current because as of July 1, 2024, the Department of Labor rule said the salary level would increase to $844. And in fact, it did for a window of time from July 1 until last Friday, November 15th, I think it was. January 1, it was proposed to go to $1128 a week, and then it was supposed to update triannually every 3 years. And I was just speculating in those question marks below what those numbers are, 1230, 1342. Those weren't locked in stone. There was going to have to be a mathematical calculation done, but it would be going up, 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 and up. Well, wait a second. Breaking news, and I mean as of last Friday, what happened? Well, there had been multiple lawsuits filed challenging the salary level increase. The one on the screen right now, the state of Texas versus United States Department of Labor, They enjoined the rule months ago for the state of Texas employees only. Now, there's a difference between injunction and summary judgment, which I won't bore you with, because what is the key takeaway for you? Last Friday, summary judgment was granted. A district court in Texas said, U.S. Department of Labor, the rule you've proposed that takes us from, and I'll jump back 2 slides, takes us from 684 to 844 to 1128, and then triennial increases thereafter automatically, is unlawful. Therefore, what does that mean? It means the rule is vacated. It vacates the 844 and the 1128. And for now, we are back to the 684 level. Let me say that again. In order to classify a worker as an exempt worker, they have to earn at least 684. We are getting bombarded with questions. Josh, we've already increased to 844. Can we go back to 684? How do we do this? I'm happy to discuss this with you. It will be unique per your situation and sort of the risk tolerance you have and the employee relations considerations that are just numerous in this situation. Needless to say, all you have to pay to classify as exempt is 684. Now, everything we talk about this morning, there's gonna be an election impact. And this is not a political presentation this morning, I can assure you. But what I can tell you as an employment lawyer who has practiced through multiple administrations, there are differences in employment law between the administrations. This is one of them. The salary level increase is something that was proposed by the Obama administration years ago. It was enjoined and set aside back then. And then it was proposed by the Biden administration. We expect the DOL will be considering over the next 30 to 60 days whether to appeal this decision to the Fifth Circuit. My crystal ball tells me even if they were there's a chance they won't appeal because they see that the political winds have shifted. The new administration coming in January will not want to propose this kind of increase. So the DOL could conserve its resources and not appeal. But I think what is probably more likely at this point is they will lodge the appeal in 60 days, and then the new Trump administration will effectively either withdraw the appeal or stay the appeal. And the way they do that is they give the guidance to the Department of Labor leadership. The Department of Labor leadership will then speak to the solicitor's office. So what does this mean? My crystal ball tells me we are at 684 now, and we will be for the foreseeable at least 4-year future. And of course, depending on what happens in the next election, that could change, but that's where we are. So that is the key takeaway. Now, action items for you for exemption compliance. Well, just because we're back to the old rule doesn't mean this is something we should just ignore. I highly commend to you that if you are gonna look at your exempt classifications, the level, the basis, and the duties test, now is still a great time to do it. Why? Because if you make any changes, from an employee relations perspective, you can simply point to the US government. When an employee says, why did you do this? There was a proposed rule that made us analyze these positions. And because of that proposed rule, we've decided to reclassify your role, or we've decided to change your salary. So now is still a great time to correct any misclassifications. Okay, there is that topic. Next, update on U.S. Department of Labor independent contractor rule. Now, for any of you who have attended any of my presentations or webinars in the past, you know this has been something we've been discussing all year. Now, just for foundational base level, independent contractor, what does this mean? If somebody's properly classified as an independent contractor, then the vast majority of employment laws do not apply to their engagement. That makes it very attractive for companies to try and classify a worker as an independent contractor. However, be aware, independent misclassification litigation and DOL audits on both the federal and state level, IRS misclassification audits, unemployment comp audits, workers' comp audits have been some of the most aggressively pursued matters over the last decade and a half, and it's not slowing down. So what do I mean by this? Many employers would love to classify their workers as independent contractors, but you can only do so if the worker meets very onerous tests. And in my experience with the Department of Labor, the default mentality is a worker as an employee. You have to almost prove to the department, and you have to prove in litigation that you've properly classified a worker. Now, it's not your burden of proof. That's not what I mean. The employee in almost every circuit that I'm aware of carries the burden of proof to show they're an employee. but we will have an obligation in summary judgment briefing to show evidence that they're an independent contractor if we were to choose to classify them as that. So I'll talk about what the test is briefly, what this change was this year, but my recommendation is if you are considering having a worker in your facility, your building, or your employment classified as independent contractor, this is not a classification you should take lightly. You should think about it carefully and consider getting advice from counsel because of the risks of misclassification. So with that sort of stump speech out of the way, what are the tests? Well, unfortunately, you see the first bullet. There's myriad tests. At one point, Littler tried to count up the number of tests, and it's over 100 tests around the country. In Pennsylvania, just to give you a small example, we've got federal tests, we've got state tests. Even at the federal level, there's a different test for the FLSA, the Federal Fair Labor Standards Act, the IRS regulations. Under state law, there's different unemployment comp tests, workers' comp tests, Pennsylvania Minimum Wage Act tests. They're all different. So what we're going to talk about today is the test that's closest. It's the new federal FLSA test, but it's also the test that's closest to the Pennsylvania Minimum Wage Act test. But just realize there is a different and more onerous test under the Pennsylvania Unemployment Comp Law. So prior to 2021, and the chronology here, if you're tracking administrations, that's exactly right. So there was a pre-2021 rule, which was effectively the Trump rule. Then there's a Biden rule that was imposed, so on and so forth. We'll walk it through. But here's my takeaway for you. The green right here on this screen and the green you'll see on the next screens. Regardless of the tests in the past, whether it's 5 factors, 9 factors, the question was, is the worker economically dependent on the company or are they in business for themselves? So let's start thinking through your CNAs, your LPNs, many of your RNs probably. If they are being scheduled, if they're being hired and fired, if they aren't operating in their own LLC, these are employees. These are not independent contractors in almost every instance that I'm aware of. Now, if you're using independent contractors and you're screaming through the screen at me, wait a second, Josh, I got an opinion letter on this. There are certain situations where if they've got their own LLC, if you are not hiring and firing, if you are not supervising their work, they're determining how to do the work, they're invoicing you, things like that. Okay, I will recognize that there are worlds where certain types of workers can be engaged as contractors. But in your industry, the vast majority of the people in your building, in your facility, are going to be employees. Just take that as a general rule. And if you want to use a contractor or you think you've got one in your building, just ensure that you're on good footing when you do it, answering this question. Are they economically dependent on you or the company, or are they in business for themselves? Now in 2021, the pre-Biden 2021 test tried to change up the test a little bit from the 6 factors or 5 factors to 2 core factors and 3 guidepost factors. It was really an attempt to simplify how you determine if somebody was a contractor. The right to control was still being focused on. The worker's opportunity for profit or loss was still being focused on. Those are 2 of the old factors. They just said, instead of having to balance all 5 or 6 or 9, we're just going to look at 2. And if they point it in the same direction, the analysis ends. If they don't, then we look at these other guidepost factors. Well, that's no longer a rule that's in place. Days after that rule had been put in place, the new Biden administration first sought to delay it and then sought to withdraw it. Lots of litigation challenges. Their prior January 2021 efforts were not successful, but then they did put out a new sort of rule that identified these 6 factors. And if these factors look familiar to you, they should, because they are effectively returning to the prior factor test. So these are the kinds of things that elucidate or answer the question of, is the worker economically dependent on your business or are they in business for themselves? These are the ones that if you want to try and self-audit your classifications, these are the factors you would need to look at. Now, it's not a quantitative test, checkbox 1, checkbox 2, then independent contractor. It is qualitative, which is what makes it so difficult to try and properly assess. Effectively, the judge or Department of Labor will say, on balance, when we look at all of these factors, does it kind of tell us it's an independent contractor, or does it tell us that the worker is economically dependent on the business? Not always easy. I've actually spent years of my life litigating that test. Yes, Asher.
If I can just bring it down to us regular guys over here and just explain what your traditional independent contractor and your traditional W-2 is, and then we'll see where, and then you'll see where these tests and these words and these compliance things fit in. So your traditional independent contractor Everyone here is in an office. Let's say the office has no heat in the building. So what do? You call up a plumber or you call up an HVAC guy and you say, please come down. That gentleman who comes down, he comes in, he usually comes when he wants. He comes in his own truck. He's usually not in the nursing home business. He's in the HVAC business. He comes in, you don't tell him how to fix the heat. He goes ahead and uses his own equipment, his own gloves, his own tools, his own knowledge. He comes in, he fixes it before he leaves. Hopefully you write him a check. Hopefully it's not too much money. You give him a check and then he goes on to somewhere else to fix someone else's heat. That's like what your traditional independent contractor is. He doesn't clock in, he doesn't clock out. He sets the rate. He's in business on his own fixing heat. That's like your traditional independent contractor, let's call it. Then you have a traditional employee who's hired by the facility, let's say, and it's hired, let's say 9 to 5. They have working 40 hours a week. They have to come in 7 to 3. They clock into your time clock. They have to clock in and out, let's say for lunch breaks. They get paid every week or bi-weekly, and they get benefits. They get PTO. If they want to call out, there's a call out policy for them. You supply the gloves. They have the CNA license, so they're kind of in the nursing CNA, LPN, or RN license, kind of in the nursing business, and they're dependent on the employer to show them what to do. You tell them, you can give them discipline, you can make them accountable for some things. They get paid by you on an hourly basis. That's your traditional W-2 employee. Then you have some people who are like in between. So let's say you call a nurse in to do a med audit on your carts. So here you have someone who's a nurse. So she's in the nursing business, but she's not an employee of yours. She's just coming in, doing an audit. She's an RN. So that's where you need Josh. But the traditional 2 ways that I explained, so everyone understands what it is. Josh, I had a question about when you Google around with these things, you hear something called the ABC test. What's the ABC test, and can you shed some light on it? Because I know people throw that around a lot.
Yeah, first, by the way, great examples you gave. Second of all, you heard me reference the Pennsylvania unemployment comp law and the fact that it had its own test. Well, it's more akin to the ABC test. States like Massachusetts, states like California, they use an ABC test. The ABC test makes it even more difficult to properly classify a worker as an independent contractor. One of the factors there is similar to one of the ones that I've been discussing, which is effectively the worker has to have an LLC or a completely separately operated business. And when you think about that, think about what it means to have a business. You've got articles of incorporation, you've registered with the state, you have your own payroll, you engage your own companies. A lot of the workers we want to try and engage don't have those things. Maybe we're engaging them through a staffing company. Maybe it's an out-of-state staffing company. And I know a lot of states have had a lot of hostility towards that industry. I think there's lots of great actors in that industry. I'm not speaking bad about it, but that industry, if they're merely sending a worker to your business, I highly commend to you to look at your staffing agreement to see what it says about each company's respective obligations and how they classify their workers or don't, because that can create some risk. That's a quick tip for you. If you have staffing agencies sending folks in your building, I would highly commend trying to understand whether they classify their workers as employees or independent contractors. But the ABC test is simply just a different test. That's the test that applies under Pennsylvania unemployment comp law. It is a different and slightly more difficult test to meet than the PMWA or FLSA economic realities test that we've been discussing this morning. So the 2024 final rule change, there was a final rule that came out this year that is attempting to further explain what these 6 factors actually mean. What it did is really just provide interpretation changes, effectively addressing what about if you're just complying with the law when you're exercising some control over the worker? Is that going to be used against the employer to say it should be an employer independent contractor? What about relative investment, so on and so forth? You see the slide here. We don't have time to go through this today, nor do I frankly think you want to know this information. It's just really in the weeds. It's things I spend years of my life litigating. I have an example this morning of the legal compliance that if you want to read this, you certainly can. But here's my action steps for independent contractor compliance. First, it's easy. Just like exemptions, just identify any independent contractors you're using. If you get audited by the Department of Labor, one of the between 5 and 11 things they ask you for is a list of your independent contractors and any 1099s you issued in the prior year. And let's demystify this, right? A 1099 is not a classification itself. It's an IRS form. It's the form you give to an independent contractor, and contrast that with the W-2 form, which is the form you give to an employee. So go to your accountant, go look in your files, see who's a 1099 last year or this year. Give some thought or audit the 6 factors to determine whether they're economically dependent on you or if they're in business for themselves. If you aren't sure or need help, reach out to counsel. We can certainly help with that. And then create a plan to address any misclassification, analyzing any back wage obligations, because remember, the statute of limitations, depending on the law we're addressing, runs anywhere from 2, 3, and in Pennsylvania, sometimes claims can be brought for 4 years. So should you pay back wages? Should you not? There's a lot of strategic considerations there. Communication plans to mitigate your risk, both the senior leadership, first level management, and then the impacted workers. If we are switching them into a timekeeping role, there's training obligations. There may be employee handbooks, so on and so forth. And by the way, speaking of handbooks, that is a common mistake I see people make. We're going to try and classify somebody as an independent contractor, but then we give them what's called an employee handbook. That's a big red flag that they're misclassified, and I've seen it done more times than not. So just be careful. If you are using independent contractors, we are not giving them the same benefits, same policies, same documents as we do an employee. We engage them completely separately, typically from the start with an independent contractor agreement. Okay, that's enough on ICs for this morning. I'm going to race through some common mistakes. So you heard me say I'm a wage and hour lawyer earlier. There are some very common mistakes that I'm seeing that are leading to litigation in long-term care assisted living facilities. In fact, I have several pieces of litigation in New York right now that are dealing with some of the things we'll talk about today. So first of all, what's a common mistake? As an employer, you have an obligation to maintain lots of information for any of your employees, including time records, clock in and out, total time worked each day, total time worked each week. Now, you can offshore that liability or that responsibility to some degree to a vendor. Maybe you use ADP, Paychex, Viventium, any one of the great vendors, WellSky, any one of the great vendors out there that may do your timekeeping or your payroll. But just remember, you can contract with them to do those things, but you ultimately retain the obligation to keep the records. So make sure you know where they are, download them periodically, and certainly to the extent you switch vendors, get your records from that vendor before you leave. It's much more difficult 6, 12, or 24 months down the road, and sometimes those records have been destroyed by then. It's much more difficult to get them down the road. So here's what you have to keep a record of: start and stop time, and the key at the bottom, pay for actual time worked. And there are myriad examples of how it becomes complicated to do this. We have people who forget to punch in and out. We have people who argue they work from home when their supervisor called them with work. If you remember very little else about all the other details I'm providing, pay for actual time worked. There's your key takeaway. If people are not following your instructions and they're working when you told them not to, use that as a disciplinary opportunity up to and potentially including termination, rather than messing with their pay. You mess with their pay and you drive them to the Department of Labor or a plaintiff's lawyer, I can promise you the pain you will feel from that is far more severe than the pain you might feel from giving them a disciplinary notice or terminating someone's employment. Okay, so this screen right here, if you want to save no other slide, this is your slide for the common wage and hour violations. We've identified a bunch of them that I experience in the audits I've had, in the litigation we're representing clients with right now. In red are the ones that I think are the most common and the ones I've seen most recently. The first one starting with meal breaks, then we've got off the clock, failure to calculate regular and overtime rate, and maintain hours worked. What I've done is in the next 5 or so slides, 5 to 10 slides, I've broken down each one of these issues in red and provided a little bit more information. So first of all, here is an actual 3 paragraphs from a recent complaint where the worker argued that they weren't paid correctly for their meal and rest breaks. For example, this was shift work at a facility. They had folks who were supposed to be coming in at 7 a.m. Then they had the night shift folks. The night shift folks said the 7 a.m. didn't show up on time. So they had to work past 7 a.m., sometimes 7:05, 7:15, before the day shift person relieved them with their duties. Well, this facility was being accused of auto clocking out that person according to the schedule and not according to actual time worked. And remember what I said is our litmus test, pay for actual time worked. So if your night shift is not finishing their shift until 7:08 or 7:15, I highly commend to you to pay them. Now, if they're not working, they just forgot to punch out, that's different. Okay. If they're not working, we have no obligation to pay. But if you see punch outs at 7:05, 7:15, I would highly commend to you, check it out. Ask them, are you working or did you just forget to punch? Create a written record of that. So you've got defensibility because what the Department of Labor does or a plaintiff's lawyer, send me your timekeeping records, send me your payroll. And they start looking through your time, adding up daily and weekly time worked. And if they worked 15 minutes past on a normal 40-hour schedule, it's going to say 40.25 in the timekeeping. Then they go over to the payroll corresponding to that work week and they say, okay, why am I only seeing 40 when the time says 40.25? Now you might say, well, I'm sure they just clocked out late. I'm sure or guessing or speculating doesn't work in litigation or with the Department of Labor. You have an obligation to keep the records. And if your records show 40.25 and you have no way of explaining or proving that it was 40, then the department and plaintiffs' lawyers and courts are typically going to assume 40.25 is what they should have been paid for. And you only paid them for 40, so you owe them 0.25 hours of time for that work week and every work week where this happened over the last 2, 3, or 4 year period in Pennsylvania. So this is just a lawsuit where this was brought. This is very real. This is happening right now. My firm and I are litigating these issues right now on behalf of folks in your industry. Here's some off the clock red flags, right? So recorded time is always a round number or the same as scheduled shift. I just gave you the example of the nurse. If they are clocking out at 7:15, but their schedule is only until 7 a.m. or 7 p.m., that's a red flag when we're starting to review your payroll. And by the way, Littler does payroll audits and compliance audits, and we effectively do mini versions and full-blown versions, just like the Department of Labor would. We look at your time, your pay, your independent contractor classifications, any of your exempt classifications, any of your child labor. In other words, are you engaging anybody under the age of 18? And if so, are you following the child labor rules? We do those sorts of audits before the Department of Labor comes knocking on your door. Just to try and help make sure you're in compliance. And you'll see why in a minute when we start talking about the exposure you can face if you make mistakes. Time records showing a significant number of missed punches or manager time adjustments. We get called on this a lot where maybe we see the manager going in and correcting time records. Maybe the manager or supervisor or scheduler is doing this legitimately. Maybe somebody texted them or called them, or maybe they're affirmatively checking the schedule every day and all the time punches. And if they see something misaligned with the schedule, they contact the worker. That is the best case scenario. I still like to have something in writing for why the change was made. Because if you're a plaintiff's lawyer or the Department of Labor, you look and see a worker has clocked in and out for 40.25 hours, but a manager or a supervisor who is tasked with keeping the overtime budget low has changed the time entry so it only shows 40 hours. Well, there could be a completely lawful explanation for that, but that could also be time shaving. So that is a red flag that the Department of Labor looks for and private lawyers look for. So I would recommend if you have folks changing time entries, we have some sort of documentation. We get a text message from a nurse or a CNA saying, hey, I clocked out late. Can you change my punch? Great. Print the text message, stick it in their personnel file or keep it somewhere. You get an email, same thing. You call somebody or they call you, send a confirmatory text or email. So we've got a record of it and we can find it if we ever get challenged. We've already talked about time punches do not match. And then supervisors, managers, care coordinators who don't understand the wage and hour rules. These are our company's representatives. They can actually create liability for our company and they can also protect our company from liability just based on their actions. So we have to make sure we're training those folks to understand the wage and hour rules, that employees are expected to be clocking in correctly, clocking out correctly according to when they actually work. They have to understand the meal break rule, that if we're going to take a 30-minute uninterrupted meal break, and by the way, I recommend it has to be at least 30 minutes. I recommend anything less than 30 minutes. We generally consider that a paid break. Over 30 minutes, however, we can consider it an unpaid break. Now, let me demystify something. There is no federal or state obligation in Pennsylvania to provide meal breaks, okay? Nothing that says, like in California, you have an obligation to provide meal breaks. There's a specific law that says you have to give at least 30 minutes after the first 5 hours of work, so on and so forth. No similar thing in Pennsylvania or federal law. What we do have is if you're going to try and create or treat that meal break as non-compensable unpaid time, then it has to be at least 30 minutes or more. And it has to be completely uninterrupted, meaning if you've got a CNA sitting in the break room, they are able to sit in the break room, watch their soaps, eat their meal, check out their phone, text their family, have a personal phone call without the supervisor or another CNA popping their head in that door saying, hey, what about bed 13? Did you administer this? Sorry, it's just 2 seconds. Can you tell me really quickly? That is an interrupted meal break. That makes the entire 30-minute period compensable. And I'm sure there are folks on this call right now whose head are exploding a little bit saying, oh boy, we have a potential issue here, because I know that's common. I've worked in lots of employment where during my meal breaks, I get a text message, I get a phone call, my boss pops in, a coworker pops in, hey, did you do X, Y, and Z? Everyone needs to be trained not to do that. Period, full stop. If you want to try and mitigate and avoid the risk of having to pay for that full break. Now, if you're using some sort of auto deduct policy, the rules don't change. And what do I mean by auto deduct? We schedule our folks for 8 hours in our or 9 hours in our building. They get a 1 hour meal break. So our system is automatically going to deduct that 1 hour or not pay them for the 1 hour. Auto deduct is not per se unlawful, but you have to remember, if they get interrupted, we have to give them a mechanism to report to us that they got interrupted so we can pay them for that. Without that mechanism, you can actually create unnecessary liability for your business. So just be aware, whether it's an auto deduct feature or you're simply providing meal breaks for folks, asking them to clock out and back in, we need to make sure we pay them for actual hours worked. It needs to be at least a 30-minute uninterrupted meal break. And if they do get interrupted, we need to pay them for that full meal break. Now, if they get a 1 hour meal break, and they only get that one interruption in the first half an hour, but they're still getting 30 uninterrupted minutes at the back half of the meal break, or vice versa, you only have to pay for the 30 minutes. You can still treat the last 30 minutes as uncompensated, non-working, uninterrupted time. Okay. The next topic I want to touch on, and this is a relatively complex one, and this is one that I feel bad for some of my smaller employers that don't have big HR or legal teams. When we talk about overtime, it's pretty much everyone knows. If you pay a worker $10 an hour, the overtime rate is typically $15 an hour. That's not brain surgery, rocket surgery, as I sometimes like to refer to it as, or brain science. Where it gets complicated is if we pay a worker any additional types of what's called remuneration. Think of bonuses, retention bonuses, performance bonuses, shift differentials, on-call pay, just any type of payment that either encourages the worker to work harder, longer, faster, stronger, rewards them for good hard work, things of that nature. Those payments actually need to be included in your overtime rate when you pay a non-exempt worker for time worked after 40 hours in a work week. Here's the formula on the screen. Total remuneration, so total straight time wages, let's say it's $10 an hour times 50 hours because they worked 50 hours in a work week, that's $500 in straight time remuneration. Well, what if you gave them a $50 performance bonus or $50 on-call pay or any sort of incentive bonus or non-discretionary bonus that has to be included? Well, then you add that into the remuneration. Let's say it's $550, and then you divide it by the total hours worked, 50 hours, that gives you the new regular rate. The new regular rate is no longer $10 an hour. It's going to be something north of that, $10.20, $10.50, $10.75. The overtime rate is then 1.5 times that new regular rate, not the old base rate. So I know this can be confusing, but what I've done here is I've listed examples of the types of additional compensation you might be paying a CNA, RN, somebody in your building that's non-exempt. Just to be clear, non-exempt. If we're dealing with an exempt worker who's properly classified, pay them whatever you want. We don't care. None of this applies because you don't have to pay them overtime. But for non-exempt workers, these additional types of remuneration have to be included. So the example is on this next screen. 52 hours in a work week, rate of pay is $12 an hour, $50 performance bonus, $25 on-call payment, $699 in total straight time earnings. But what about the overtime? Well, the incorrect way to do this calculation is to simply take their $12 an hour rate times 0.5 times the 12 overtime hours and say, okay, they get $72 in overtime premium earnings, $771 in total earnings. We're done, right, Josh? Unfortunately, no. The correct calculation is adding in that other type of on-call pay and the bonus we gave them into the regular rate calculation. So the regular rate is actually $13.44 when we do the math, not $12. And then when we pay that at the proper overtime rate, the amount they should get is $80.64. And so total comp to that worker is now $779.64, not the $771. Now you might be saying, and I've got this on the bottom right-hand side of the screen. All right, come on, Josh, you're telling me $864 a week, we really care about that delta? The answer is yes, and here's why. 864, and let's say you did this every week for the course of the 3-year statute of limitations. And by the way, I just used 3 and not 4. It actually would be larger if we were getting an unjust enrichment claim in Pennsylvania brought against us. But for purposes of federal law and several of the Pennsylvania state law claims, assuming a 3-year statute. So 864 a week times 156 weeks equals $1,347 per employee in back wages owed. Now, if it was a single employee, you could also have liquidated damages and potentially civil money penalties assessed, depending on if it's a private plaintiff litigation or a Department of Labor audit. Liquidated damages awarded in an amount equal to the back wages. So if you have $1,300 in change in back wages, you have $1,300 in change potentially assessed in liquidated damages, unless you can set up a good faith defense. CMPs are an amount in another amount that could be added in a DOL audit. Well, then it's not just single plaintiffs, right? I'm a class and collective action lawyer. So the vast majority of cases I see, and for example, CNA cases we're defending right now in this industry for wage and hour mistakes, they bring those on a class basis or a collective basis, saying not just the one worker, but everyone in that job title who was subject to that policy is part of this group. So maybe you've got 50, maybe you've got 20, maybe you've got 100 or 500 workers in this group. We look at the last 3 or 4 years, find out how many times they weren't paid correctly, and that is the scope of your potential exposure. As you can imagine, it adds up quickly, and we're usually talking about 6, if not 7 figures, and I've actually seen 8-figure damages amounts as well. So this is not the sky is falling. If you have this problem buried, what are some resources? I've identified several for you in the slides today. And we certainly can circulate these slides afterwards. But one of the first things I want to commend to you or recommend to you is the Department of Labor's website. There is a lot of good information about wage and hour compliance on their website. And as I note in the title of the slide, the best part is it's free. Google it. I know lots of us Google things on a regular basis. The Department of Labor's website, you simply Google U.S. Department of Labor regular rate calculation, U.S. Department of Labor non-discretionary bonus, U.S. Department of Labor fill in the blank travel time pay, whatever it might be. It's a great resource for you. In addition, audit your practices. One of the best ways to show you've acted in good faith is to audit your practices and try and come into compliance. It allows you to identify and fix issues up front. For example, if you sent me your payroll and I look at your non-exempt workforce and I see a $50 payment, $500 payment, I'm immediately going to ask you what that is. If it's a discretionary bonus, fine. If it's something like a pure sign-on bonus that doesn't have a retention component, fine. We don't have to worry about that for a regular rate calculation. But if there's a retention component to that sign-on bonus, they have to stay 60, 90, or 120 days or something. If it's a shift differential, if it's a performance bonus, whatever non-discretionary bonuses, if you're not paying that part in the regular rate, I'm going to see it on the face of the payroll record. So audit now helps you fix the issue. If you can set up a good faith defense, it also helps you avoid liquidated damages and potentially civil money penalties.
Josh,
Helps you develop an evidentiary record. Yeah, Asher.
I'm sure a lot of us here have, and I know I do have, a referral fee. When you refer a friend over to the employment, everyone's struggling with hiring. So we sometimes give a significant one, $250, $500 referral bonus. Does that have to be added into the hourlies?
Funny enough, it depends on the title of the position of the person and the duties of the person that's getting the referral bonus. Generally speaking, referral bonuses, if it's part of I'm sorry, are you paying the referral bonus to a current employee or to the person who came into your business as effectively a sign-on bonus?
Let's talk about the current employee who
Yeah.
referred a friend to come here.
So if the referral bonus is being paid to someone who part of their job duties is to find new workers or find consumers, then yes, that is a performance bonus that's includable in the regular rate, right?
Mhm.
Because you're effectively paying them for doing something better, faster, stronger, longer. If by contrast, let's say you have a CNA who it is not part of their duties to recruit other workers or consumers or patients. They just happen to do it, and you want to incentivize that because there's good reason for you to incentivize it. That person, it would not be included in their regular rate. So I hate to make it sound complicated, but it really does depend on their job.
No, that makes sense. I would say most of us here, have a sign hanging by the time clock, and most of us are not recruiters saying, "Hey, refer your friend to come here," and there's a bonus sometimes just for our employees, sometimes for the new employee as well.
Great question. Yeah.
And the travel reimbursement or travel does that have to be included?
The travel reimbursement. So if you are paying for like compensable for travel time is included in the overall calculation. It is just like hours worked. And that's another good question. And I also want to address the mileage reimbursement too, which is a completely separate issue. Any hours worked, whether it's in training, onboarding, travel time, meetings, care time, actual duty time, is calculated for or counted for our total hours worked. So maybe you've got 40 hours of actual on-duty time, but then they have another hour-long meeting they're required to attend, or they had training that week. That person actually worked 41 hours, not 40. So they are owed overtime. Now, you can pay different rates for different types of work. That's completely lawful. And when you go to figure out your overtime rate, just use the weighted average is my recommendation. It's not the weighted average is relatively straightforward. Rate times number of hours at that rate, rate times number of hours at that rate. Add those two totals together, divide by all hours worked, that's your regular rate, multiply by 0.5 to determine your overtime premium, pay that for any of the overtime hours. Now, something that's easily misunderstood, mileage reimbursement or expense reimbursements, that is different than compensable travel time hours. And what do I mean by compensable travel time hours? For example, if you had someone go from your facility at 8 a.m., they worked 8 to 9, maybe they had a meeting. Then they went to another site for work-related purposes. The travel time between your facility and the site would be compensable travel time. And similarly, coming back to the facility would be compensable travel time. Now remember, travel time from home to work at the beginning of the day, work to home at the end of the day, not compensable, but travel during the workday would be. Some employers, first of all, you have to pay for the travel time, so they pay $7.25 or whatever the travel rate is, but then they also reimburse for mileage. It's nice to do both. There's no federal or state obligation to do both. You simply have to pay for hours worked at the appropriate rate. There's no mileage reimbursement requirement unless when they incur the mileage for you, it would cause their base rate to drop below minimum wage. But usually our workers make enough that that's not going to happen. Expense reimbursements are not payments for work performed. So they are not included in the regular rate calculation. Great question.
One last question on this, because this is interesting. We actually rolled out a no call out policy, which I'm sure many of us here on the call have struggled with call outs. You get a call in the morning at 5 a.m. I'm calling out for my 7 a.m. shift. And then you have to struggle. You call an agency. Sometimes the agency calls out. So in order to incentivize good behaviors, we do, if you don't call out the whole month, you get $50 or $100. Would that fall into the performance? And then my follow-up question to that is, what's with the gift card? Like, when you do a gift card, is that legal?
Yeah, so it would fall within, and it's because of what you said it was being provided for. It's for performance.
Performance.
You are
Got it.
incentivizing them to come to work, do so more regularly. It's performance related, so that would be included. Now, with regards to gift cards, the method in which you pay the money to someone doesn't change whether it's includable or excludable. Now, this is an area that we could probably do an entire separate webinar, because sometimes folks are giving gift cards not because, for example, in your example, show up every day to work and I'll give you a $50 gift card to Applebee's, $50 gift, Starbucks gift card, whatever it is. Some people are giving these gift cards as part of points systems that are effectively more of a pure lottery just because they're an employee and less related to performance. Now, they might get points. If you get a compliment from a patient, you get 3 points. And then at the end of the month, all of your points, you get the number of points is the number of times your name is added into the bucket. You do a raffle. I don't want to get too far in the weeds there because the answers are relatively complicated and it depends on what you're paying the money for or giving the gift card for. But generally speaking, just remember the method of how you pay this doesn't matter. The other thing I'll mention, I'm not an IRS lawyer, but from a wage and hour perspective, just remember, if you pay in cash, if you pay someone in gift cards for performance related, that is still compensation, remuneration, income. So for wage and hour, we have to track it. For IRS tax purposes, we have to track it. For unemployment comp purposes, we have to track it. A lot of my clients ask, well, Josh, I just paid him cash. Josh, I just paid him in a gift card. That doesn't have to be on the payroll. Not so fast, my friend. That will actually create liability for you as well. We have some slides here on the good faith defense. The good faith defense I want to talk about just very briefly. Liquidated damages. You heard me say it's assessed in an equal amount to the back wages owed. There's also a statute of limitations piece of this that you can have a 3-year statute or a 2-year statute. If you can set up a good faith defense even if you violated the FLSA, you can actually have a 2/3 reduction in your potential exposure because we take your 3-year statute down to 2, and they don't assess liquidated damages in an amount equal to your back wages. So in order to set that up, you have to show concrete steps. You have to have some proof or be able to testify yourself that you took steps to ascertain the requirements of the loss, whether it's travel time, whether it's bonuses, whatever it might be. You tried to figure it out. Doesn't have to be talking to a lawyer, but talking to the lawyer or talking to the Department of Labor is the best evidence of good faith efforts. Once you figure out what you think the rule is, you need to try and act in conformity with your understanding of the requirements. And by the way, it is not a defense, and it does not set up the good faith defense for you to say, well, I have a payroll company. Weren't they responsible for that? That's not a good faith defense. Now, if you went to the payroll company, you asked them to confirm for you that they were complying with the overtime requirements or they were paying correctly, and they did in fact confirm that for you, preferably in writing, that may support a good faith defense. But the vast majority of my clients don't do that. They just say, I have ADP, they're covering me, right? Question mark. You actually have to take affirmative, and I'm not saying ADP isn't covering you. I'm just saying that alone is not going to help support a good faith defense. So good faith defense, very, very valuable. It can save you a lot of money. Here's the example on the screen, walking through the prior example of the exposure. A good faith defense, even if you have a violation, can drop you from 269,000. Let's assume you had, excuse me, 100 workers in that position, plus civil money penalties if it's a DOL audit, and it can drop you down to 89,000, more than basically a 2/3 reduction, not including the CMPs, just because you could set up a good faith defense. Hugely important. There's a huge tip takeaway today. Set up the good faith defense for your wage and hour practices. I'm happy to help you with that. It's relatively cost effective to do. 2 other tips. EPLI insurance for employment claims generally. I know EPLI premiums can be high sometimes. EPLI just stands for Employment Practices Liability Insurance. Effectively, if you got sued for discrimination, once you've met, it's just like car insurance. Once you meet your deductible or your self-insured retention, then the insurance kicks in to cover typically both your legal defense fees, but also any judgment entered in that case. So EPLI insurance, if you can afford it, is a very, very effective tool in your tool belt to mitigate your risk of a big exposure down the road. It's just like car insurance. The second thing I would highly recommend to you, and this is actually probably a little more cost effective, is an arbitration agreement with a class and collective action waiver with your workforce. Why do I recommend this? Because if you have a valid, well-drafted arbitration agreement with a class and collective action waiver with your workforce, one of them tries to sue you on a class and collective action basis, it gives me one of the great joys of my life. I get to go to opposing counsel. I get to hold the arbitration agreement up and say, I'm sorry, you have to go to individual arbitration. You can't proceed as a class action. And so what does that mean? We go back to the potential $1,347 in potential exposure for that one employee, and we never start even talking about the $89,000 to $269,000 in potential exposure for other employees, because you can't bring a class action in individual arbitration pursuant to that arbitration agreement. That document is relatively cost effective to put in place. The most important part, making sure it's a lawfully drafted document for your jurisdiction, and how you roll it out. Those are the 2 keys. I can't tell you the number of times clients have called me. I just got this call this week, and I'm jumping on a call today with a client that said, we started rolling out the arbitration agreement you drafted for us, but we didn't finish. And sure enough, one of the employees who didn't sign the arbitration agreement is the one that sued us on a class action basis. But the good news is, whatever portion of their workforce did sign the agreement, well, they can't join the case. But the bad news is, whoever didn't can join the case. Some more resources. We've got a home care toolkit, healthcare toolkit here at Littler that we were more than happy to talk to you about. Lots of great information for helping put you in compliance. We have a few more ways to fix, and one of them I definitely want to touch on, time certifications. Asher and I were a match made in heaven when we start talking about how to fix wage and hour mistakes, because I always talk about having a time certification, having your employee do something that indicates that they're reporting their hours worked correctly to you. And Asher, I don't know if you want to talk about this shot we have on the screen and some of your solutions for things like that, but this will be a great time for you to do that. And I think you're on mute.
Yeah.
There you go.
Yeah. So as many of us know, we have employees who need to take a break. So in the middle of the 8-hour shift, many times they're taking a break. So some of us have a clock in and out at break time, they clock in, they clock out. Then some nurses are good about it, some are not good about it. Some of you have agency workers coming in and out. Are they taking breaks? Are they not? So what we've created at eShift is a screen that as a nurse is clocking out of their shift, they'll look over their hours and they'll say, my shift time was 7 to 3. I clocked in at, let's say, 7:01, clocked out at 3:03. Okay, I'm going to get paid for all that time. And then they're consenting, as you can see, that I've taken my unpaid meal period. So it's super clear. It doesn't say lunch. It's an unpaid meal period. And they're consenting that they took it. So if years later or whatever it is, they come back, they say, oh, I didn't take my break or I was interrupted. Over here, they're consenting that they took the break. If they did not take the break, they have to give a reason why they didn't take the break, because it's in the policy that they're supposed to take a break. Working 8 hours without a break is difficult. However, just so we know, if they click that not taken, we pay them for the break. So that's kind of our way of, instead of them running to the office and saying, oh, I want an unpaid, I want something to get paid through my lunch break. Over here is the way to do it. You may end up paying a little bit more for lunch breaks for people who did not take breaks. However, you're saving yourself down the line, and you can discipline. You say, hey, if you consistently can not take your lunch break, then we're going to have to do something about it, or whatever it is. But like this, we know it's documented, it's clear that we're in compliance.
This is huge. And this gives me one of my other favorite moments of my career, when I get to sit in a deposition and I get to hold up a complaint that a worker has filed that said, I haven't been paid all hours worked correctly. And then I can hold up their time records with certifications like this, that they've indicated to us that their time was accurate. And I get to ask that magical Perry Mason Matlock question of, were you lying then or are you lying now? And in my head, I hear lots of applause when I ask that question, and I watch opposing counsel and I watch the plaintiff sort of shrink down in their chairs, get really red and flushed in the face. It's a great moment for me. So please give me that opportunity. Get some time certifications in place with your workforce. Here's some other ways to fix taking the unpaid wage report seriously. You're typically going to have a grace period with your workers. If you fix it right away, they're not going to go complain to a plaintiff's lawyer or the Department of Labor. Now, if it happens repeatedly, it might be a different situation, but take them seriously, investigate them, and then pay folks if you need to. Here's a slide with some contact information. QR code will actually let you schedule some time on my calendar for a legal consult. Of course, eShift's contact information is here as well. Now we've got about 4 minutes left, so I'm going to do the hyperspeed 10,000-foot view of a couple of these last updates. Most important, though, is the FTC's non-compete ban. Effectively, the FTC came out for the first time in the history of the FTC that I'm aware of and tried to say nationwide, you cannot use a non-compete. Now, this is different than a non-solicitor confidentiality agreement, but basically that paragraph that says you can't go work for a competitor for a period of time after you leave our employment. They tried to ban that. Well, that ban got challenged. There was a lawsuit, and that ban actually was vacated. So we are back to the world of, it was supposed to go into effect September 4th, but the breaking news is the Texas court vacated that ban. Now, the FTC has now appealed that decision because they want to enforce this ban. But again, looking at the crystal ball in front of me with the new Trump administration coming in, my full expectation is that administration will either withdraw or seek to stay the appeal, meaning the ban will not go into effect at least for the next 4 years. So what are your action items for this? If you're currently using non-competes, it is still technically lawful as long as the non-compete or any of your restrictive covenants, the confidentiality, non-solicitor, non-compete, are in compliance with state law. So for you, the Commonwealth of Pennsylvania law that talks about how narrowly defined the geographic area has to be, how narrowly defined the temporal proximity has to be, how you define the competitive companies that they can or can't go work for, their particular level of job position, all of that is state law dictated. Now, if you don't have a confidentiality and restrictive covenant agreement that includes things like a non-solicitor non-compete, you can certainly put one into place. We're happy to help you with that. It's not a really complicated document, and typically I recommend them for your senior level leadership, COO, CEO, CFO, people who have access to private and confidential information that helps your business differentiate from other businesses. I call it the Coke, the equivalent recipe to Coke. Those are important for protecting your customer lists, your pricing, referral sources, so on and so forth. Okay, last topic. We've got a minute. The only thing I'll mention on this, if you have not updated your handbook in a while, and what's a while, more than a year, now is a great time to do it. I'm putting on the screen lots of examples of potentially problematic handbook policies under the new NLRB guidance. Now, of course, the administration will change this, but it won't be a change that happens in January. So over the course of the next 6 to 12 months, we could see NLRB enforcement actions. And by the way, I should have mentioned, even for private employers, this applies to you. Okay, so just because you don't have a union in your workforce, that's not a get out of jail free card here. The recent NLRB decision that makes it more difficult, I shouldn't say more difficult, the NLRB is going to be scrutinizing handbook policies more closely to see if it violates the NLRA. I'm putting on the screen several examples of the types of handbook policies that could be problematic depending on how they're drafted. Here's one of my favorite ones. I'll let you look at those at your opportunity, but the takeaway here is, when's the last time you've updated your handbook? If you're in Pennsylvania, the city of Pittsburgh, Allegheny County, Philadelphia, lots of new laws have come out that may apply to your workforce, paid sick leave, so on and so forth. It is time, if you have not done it in a while, to look at your handbook, review it, revise it, and update it. Lots of ways to do that. Littler would certainly be more than happy to help you with that. We have an entire handbook group, a Policy Smart solution, all very cost effective to ensure that you're in compliance with federal, state, and local laws. Okay. Joint employment rule, nothing to really touch on there. There was a rule the NLRB put out that was going to make it easier to consider two separate companies to be the joint employers of a worker. But that rule has been enjoined, so we don't need to worry about it anymore. How's that for a 10,000-foot high-level view? And I think that was the last thing we had for our topics today. So thank you all very much for joining us. If you have questions, please feel free to reach out. And if not, we hope to see you on either the next Pennsylvania Healthcare Association webinar, or Littler webinar, or ESHYFT webinar. Thanks so much, everybody. Take care. Have a great day.
Thank you, everyone,
So
for
much.
joining.
Josh, if you could send me the PowerPoint so I could share it with attendees, that'd be great.
Yep.
And I didn't see any other questions come through. So as a general reminder, please reach out to Josh, Asher, or myself if you do have any questions that arise after today's session. And I appreciate everyone's time today. Thank you so very much.